I think we're ready to begin this last panel. So if you all could take your seats, we'll finish up here. I know some people have already had to step out, but I'm really looking forward to this last panel, and I know that that many of you are. This has been a topic that I know was of significant import to the Commission and is obviously an important issue in criminal justice in Indian country. So panel 4 will discuss juvenile justice, which is chapter 6 of the Commission's report. So the commissioners speaking today will be Judge Pouley, Commissioner Pouley, Commissioner Goldberg, and Commissioner Ellis. And our commentator is Addie Rolnick, who's a professor at UNLV, and I will moderate. So we'll give our commissioners each around 10 minutes each to talk, and then Professor Rollnick will speak for about 15 to 20 minutes, and then I'll return to the podium. Thank you. Oh, and go in whatever order you see fit.
Good afternoon. This is late in the day, and this might be the hardest subject of the day as well. So, you know I'm Commissioner Pouley, and you know I'm a Tulalip Tribal Court judge. What you don't know is that I'm the mother of 4 children, the youngest of which is a daughter. And when I testified before Congress, I told Senator Dorgan that I never wanted to look in my daughter's eyes and have her be one of the statistics of being 1 in 3 Indian children who are raped, or 1 in 3 Indian women who are raped in their lifetime. Tribal Law and Order Act passed, and Senator Dorgan agreed with that. And I am not going to live with the prospect that my daughter is going to be 1 in 3 Indian women raped in her lifetime. I now have a beautiful grandson, 1 month older than Commissioner Ellis's daughter, so there'll be future meetings, I'm sure. And I am here to say that it is my intention that I never look in my grandson's eyes and see that any of these statistics are about him. Indian children are among the least well group of children by race in the United States. The opening paragraph of the chapter is about those statistics, and I'm so lucky I got to have lunch with Miss Rockwell, who is one of the UCLA students who worked with Professor Goldberg to put together this chapter. And these statistics should absolutely shake every single person in this room to their core. So Indian children, 1/4 of them live in poverty versus 13% of the rest of the children in the United States. The graduation from high school rate is 17% lower than any other group in the United States. They live 2.4 years less. They have substance abuse rates that are twice as high as children of any other race. They're twice as likely as any other race to die before they reach the age of 24. They're 2.3 times higher rate of exposure to trauma. They have 2 times the rate of abuse and neglect. They're 2.3 times more likely to commit suicide. They experience post-traumatic stress disorder at 3 times the rate of the general population. And the chapter points out to you that that is roughly the rate as soldiers returning from Afghanistan. This is the state of children in Indian country. And we absolutely, positively, if you take one message with you or 1 page away with you, you absolutely, positively have to do something about that. We have to know where our children are. In 1978, the federal government passed the Indian Child Welfare Act, and in large response to tribal leaders who said, the children are our future. They are the future of our tribes. And if this is any indication of what the future looks like, it's time for us to step up and intervene. In combination with all of these statistics about the wellness, or really the lack of wellness in Indian children, the other thing that is absolutely dramatically portrayed in this chapter is we don't know where they are. Indian children wind up in the state system in juvenile detention. They wind up there as truants. They're removed from their homes at a rate that's alarmingly higher than the rest of the population. They end up in federal prison. The majority of children who are in the federal prison system in any particular year are guess of what race? They're Indian children. And we cannot, despite our best efforts, get the numbers on how many Indian children are in state or federal facilities. We don't even know how many Indian children are in tribal facilities. So when you're looking at these absolutely sobering statistics, you have to say, we have to do it better. And this is one of the times when we absolutely positively do. For many Indian tribes, I would venture to say the majority of any Indian tribes, the majority of their population is under the age of 18. We simply cannot replicate a system that throws abused and neglected children in jail, period. So to talk about detention and detention alternatives and juvenile justice issues, the commission made a variety of recommendations. One of them is just recognizing the statistics and the fact that we don't know where they are. So getting federal resources and federal support, and through the Attorney General's task force, having children identified as Indian children to be able to get a grasp on the scope of the problem is absolutely critical. We also need to change the system of federal and state control over Indian children. You know, the Indian Child Welfare Act was passed because Indian children were being adopted out as abused and neglected children, in some states over 200% more than children of any other race. The Indian Child Welfare Act provided notice and an opportunity for a hearing to tribes when Indian children were placed outside of their homes and outside of their tribes. How is placing them in detention not placing them out of their homes or out of their tribes? At a time when Indian children need the most help, they are the least identified. So there is recommendations in the report that the Indian Child Welfare Act should be amended to provide notice to tribes when children are put into either state or federal custody so that tribes can intervene. It would extend the provisions of the Indian Child Welfare Act to allow tribes to provide input and intervention in state and federal court proceedings. It would also allow tribes to bring those cases home, as in Indian Child Welfare Act cases. It's only in that instance when tribes have the ability to be able to know where their children are and to be able to leverage their services to provide for these children that we're going to see a fundamental change. The report also says, and this is a little bit cutting edge just in juvenile justice issues generally, we should not be incarcerating our children. That all children should have trauma-informed screening to figure out whether or not they have been traumatized, to identify the instances of PTSD, to get them appropriate mental health training and mental health treatment and substance abuse treatment if necessary, because here's the thing, they're kids. So if we intervene and toss a child in a detention facility, we are imprinting on his brain forever and thwarting adolescent brain development forever, and then we wonder why as an adult he's a criminal. So getting that kind of treatment and those services to Indian children early and requiring screening is one of the requirements of the report. A couple of the other requirements are just changes to federal law, which are so simple. So, for example, the reason Indian children end up in federal prison is because of the Federal Delinquency Act that says that they have jurisdiction over Indian children, and there's a particular provision in the law that says that a state can intervene so that they can bring it into state jurisdiction, but it just doesn't include the word tribe. Carole does a great job at sort of explaining how that all operates, but simply including the word and tribe in the Federal Delinquency Act would stop the federal prosecution of Indian children. So changing federal law, giving notice to tribes in a variety of different mechanisms, and getting them adequate screening really are the recommendations of the report. I absolutely refuse to look in my grandson's eyes on any day and think that he is going to be one of those traumatized children. He deserves better, and it's my job to make sure that that happens. So I hope each and every one of you understands and carries this chapter with you, because the state of Indian children is an absolute crisis, and all of our children deserve better.
Well, no dissent to all of that. I hope you all can appreciate that if we had had nothing on our commission but the passion that Chief Judge Pouley brought to this issue of improving juvenile justice for Indian country, we would have had enough to go forward with the right things to do. We did more than that. We didn't doubt anything you were saying, but we also heard from quite a few people throughout Indian country about their experiences with federal and state juvenile justice systems. We visited facilities that were for the detention of juveniles, found some very disturbing features. In some of them, educational services were not being provided at all to the incarcerated youth, doubtless in violation of law, but that's what was going on. At the same time, we also saw some very heartening examples of tribal initiatives, tribal facilities, for example, in Arizona that were using environmentally oriented projects to engage youth and provide them with a positive direction in life and providing them with very effective education within the detention facility. We saw programs such as those at Wind River involving boys and girls clubs that were, again, providing very positive outlets for youth without the need for detention. But we knew in this report that we needed to be strong and forceful in our recommendations, which may lead you to question why it is that the juvenile justice chapter is the last chapter in the report. At one point in time, we had contemplated making it the second chapter in the report because we thought both that it was an important, vitally important subject, and second, that the sympathy that is often generated for the situations of youth, even youth who get in trouble with the law, may be helpful in advancing the overall agenda of the commission. At the end of the day, this wound up as the last chapter in the commission's report because it became evident that every single one, except, well, maybe even including Alaska, of the other chapters had ideas and recommendations built into it that could be properly adapted for juvenile justice. And I'll walk you through many of these. So at the very basic level, our grand bargain on jurisdiction, that tribes be able to opt out or opt back in, fully or partially, of federal and state jurisdiction, ought to apply, in our view, as well to juvenile justice. So if the federal or state justice systems are not working for Indian country youth, tribes should be able to exit them altogether if they wish. So that's chapter 1. Okay. If we go to the chapter dealing with strengthening tribal justice, all of the recommendations having to do with providing more consolidated funding, more sensible funding, more equal funding to all tribes, all of these recommendations applied equally to juvenile justice. If you think about the chapters dealing with alternatives to incarceration, as Judge Pouley has pointed out, they apply even more forcefully to juvenile justice. We heard from the Annie E. Casey Foundation spokesperson and others throughout Indian country about the campaign to eliminate detention for juveniles across the board, both inside and outside Indian country. These were powerful voices, and we thought our chapter having to do with alternatives to detention needed to be applied in Indian country to juvenile justice. On the issues of intergovernmental relations, here's where our concerns about the Federal Juvenile Delinquency Act became relevant. So it was evident to us from the very beginning that the federal juvenile justice system was not suitable because the federal justice system is not designed or equipped to deal with juveniles more generally. There is a very small docket of juvenile matters that arises outside of Indian country. These are federal laws of general application that happen to have been violated by a juvenile. Okay? But for the most part, the people who get drawn into the federal juvenile justice system are Native children, and the system isn't designed for them. So we wanted to ensure that there was a way to minimize the use of federal juvenile justice where tribes have chosen not to opt out. And the way we did it is through what Judge Pouley described, that is taking a very simple change to the Federal Delinquency Act, which currently specifies that if there is a juvenile who is subject to state jurisdiction, who is brought before the federal system, they can be brought as a juvenile before the federal system only if the federal prosecutor certifies to the court after investigation that one of three conditions exist. Either that the state court does not have jurisdiction or refuses to assume jurisdiction. Second, that the state doesn't have available programs and services adequate to the needs of juveniles. Or third, that the offense is a violent felony or a specified drug offense in which there is a substantial federal interest. Unless one of those three conditions exists, a federal prosecutor may not take a juvenile before the federal system if there is state jurisdiction. And all we want to say is that that should apply if a tribe has jurisdiction as well. So even if a tribe chooses not to opt out of federal jurisdiction, this one change would dramatically contract the number of Native youth who would be subject to prosecution in the federal system. We also provide in our recommendations that if a juvenile does wind up, despite all this, before the federal system, that they should not be prosecuted as an adult unless the tribe agrees. So one of the models for tribal involvement in decisions about prosecution is the provision in the Federal Death Penalty Act that allows tribes to opt out of the federal death penalty provision. Now that's a sort of a blanket opt-out. It's not case by case. But we think it should be applied individually in these situations where a juvenile is being recommended for prosecution as an adult. We also have recommendations for the juveniles who wind up before the state systems. You heard from Judge Rolnick that 85% of the youth in Alaska state juvenile system are Native youth. This is a huge problem, and here our major recommendation is to deal with an analogy to the Indian Child Welfare Act, to take out that restriction that says the Indian Child Welfare Act does not apply to delinquency matters and extend it, which I think would have a huge benefit in terms of tribal control. So I will wrap up here by saying that we think that these are some of the most far-reaching and desperately needed changes that we have recommended in this commission report. Alaska may have gotten all the press so far, but we think, in light of the needs of the future of Indian country and the passionate concerns that Judge Pouley has educated us all about, that there is nothing more important in this report than what we have said in Chapter 6. Thank you.
I want to thank everybody for the organizers of this conference for putting me on this particular panel. I'll be very candid with you. Of all the chapters that we discuss in our report, this one definitely causes me the most uncomfort. Because I know when we say tribes need to have more control over what happens to their juveniles, someone's going to come up with a horrible example of a juvenile doing something truly despicable to another human being on their reservation. And sure enough, our report comes out, and in Wyoming, there's an awful case about a couple of Indian kids who pretty much beat to death a person on a bike trail because they were bored and they had heard there were some rumors that this particular person was talking smack about them, and that was their way of addressing this situation. And so, rightfully, people are saying, you've got some heinous crimes going on in reservations that kids are committing, and yet you want to be soft on them. And so I think, we need to address some assumptions. The assumption is going to be that tribes are going to be soft on these kids, or somehow they're not going to be held accountable. And so I think getting behind this recommendation, I've had to check that assumption with myself. And I don't think that that's necessarily going to be the case. I think you're going to find situations like Wind River where you've had the HPPG program, and I'm going to jump around a little bit throughout a report, but Wind River kind of provides a great example of it. HPPG, as you recall, was an increased law enforcement effort. One of the things we kept hearing was, we're just arresting a whole bunch of kids, but we have to let them go. But it's not necessarily a bad thing, because a lot of times law enforcement will show up, break up a party where maybe kids are consuming alcohol or doing drugs, and break up that activity, and less serious crime happens when you break up those parties. And so it makes sense, even if these kids maybe weren't prosecuted or spent any time, in tribal court, at least situations didn't rise or escalate where crimes became more serious. So, I appreciate our comments about law enforcement, but I just wanted to add that particular observation about increased law enforcement under HPPG at Wind River. And all of this is to say, looking at our recommendations, as Commissioner Goldberg outlined, what are our options? We've got kids that are getting involved in a federal system. So do we want to spend our efforts trying to fix a federal system to accommodate the needs of juvenile Native youth? To me, I'd prefer to see that not have to be a resource that we work on, or something we work on. Should we look at state systems and having our kids going to state juvenile detention facilities? And I think Commissioner Goldberg could very eloquently tell you, we're moving away from this notion that states can do the jobs on reservations better. So we really are looking at tribes. And I think Professor Fletcher today has really challenged our notions about, our assumptions that things are going well in Indian country. And, we need to expect more from tribal governments. And I think, and I just want to make this point very clear, we don't say it out loud in our report, but I think if you read our report, it's a definite call on all tribal governments to do a better job in all areas. And we've sung the praises of the Tulalip Tribal Court. We know Judge Pouley's on it. But to all tribal courts out there, if you read our report, you'll see what's not said is, a call to you. This all works better when tribal governments work better. So I just want that to be clear, that we certainly understand that there are some tribal governments out there that need to expect more, and tribal citizens that need to expect more from their governments. But the information that we have about Native youth is just troubling. And it's right that people like me feel uncomfortable. And that uncomfort will hopefully lead to some discussion and action on our recommendations. So I didn't take up very much time, but we'll just move on.
Good afternoon. So I teach a class around this time, and it's not the most active time for anyone, so sorry. I am very excited about juvenile justice, and so I'll try to make it more exciting for you to listen to because it's exciting to me. So my name's Addie Rollnick. I teach at the University of Nevada, Las Vegas, but I got my law degree here. And I have been, in some fashion, trying to think about and work on tribal juvenile systems for about 15 years now. And this is the first time that anyone's ever asked me to come talk about it. So basically, I do it on the side. I wrote a policy brief called A Tangled Web of Justice that in 2008, and I did it while I was working at a law firm. And the month that I wrote it, I partnered with a juvenile justice organization who wanted to write about Native youth and their issues. And so I did it on the side. I billed 90 hours at my firm. You're supposed to bill like twice that. And so I I did this project, and it wasn't driven by, so I was interested, but I was in DC, I was sort of in the middle of the national policy for Indian country, and nobody really cared that much at the national level, even though I knew tribes cared. And so it actually took a partnership with this non-Indian juvenile justice organization to get that policy brief out, and depressingly, it's still kind of the only thing out there. So all we did was amalgamate the statistics that we could find, and nothing's really been done since then. And I know tribes, so I've worked with tribes both in building their systems and in lobbying for more resources for their systems, and I know that they care about juvenile issues a lot. I know that a lot of tribes where the whole reason that they wanted to build a jail or a court in the first place was juveniles, and then it blossomed into a bigger system, but it started with the kids. And nobody really cares at a national level. So there's no organization devoted to thinking about juvenile justice policy for tribes. There are no conversations like this. So the first thing I will say is thank you for writing a chapter in the report about it. And I usually try to make about 3 points, and I have 3.5 pages of notes, and I want to actually address every recommendation. So I'll try to sort of pull it all together. Juvenile justice, and particularly juvenile justice in Indian country, is extremely invisible. And at the same time, I actually think, and a lot of others have touched on this, but this is the greatest opportunity for improvement is in the juvenile system for two reasons. So one is the worst of the problems at all levels of the juvenile system are caused by sort of a lack of attention and a lack of informed policy, and they're not actually that complicated. So this amendment to the Federal Juvenile Delinquency Act is huge, and it should have been obvious to anyone who looked, and it's not really that controversial, but nobody really bothered to look before. And so there's a lot of changes that can be made that I think do not implicate partisan concerns and do not actually implicate major changes to federal law. So that's different from some of the other chapters. And then the other aspect about juvenile courts is they really exist in this kind of in-between space that Professor Riley mentioned in a comment about sort of where tribes can really be creative, because not only do tribes have a unique status in terms of what they can do in their courts, but the juvenile system, even outside the tribal context, is not quite a criminal system, and so it can look different. And so there's actually a lot of room for creativity there, and I think that really good stuff can happen really easily in the juvenile context, and then that can serve as models, first of all, for the rest of criminal justice in Indian country, and second of all, for juvenile systems outside of Indian country. So a lot of the issues that you've heard about on the other panels apply in the juvenile context, but I think this is actually the place to start in implementing them, and it will be the easiest. A couple of overall things that I really appreciated about the report. One is the focus on trauma, so the discussion of trauma. That's something that I hadn't seen sort of tied into juvenile justice quite as well ever before. And it really helps to blur the line between the defendants and the victims. And that's something that came up, this sort of adversarial system, victim-focused, defendant-focused on the other panels. And it's easier to think about this in the juvenile context, but it's true everywhere. There's the same people. And so by focusing on the trauma and sort of the intergenerational effect, I think it really helps to show that. Some of the recommendations that I think are revolutionary, so grant consolidation, the idea of tribes being able to pick what they want to spend their money on and having it not be tied to something specific or some policy priority that they have to recreate every year is probably will make the most enormous difference for tribes being able to build juvenile systems. The Federal Juvenile Delinquency Act amendment is also huge, and I'll talk more about how I think that it's actually even simpler. And administrative consolidation, the idea of moving justice services over to one agency in Department of Justice is also huge because, as I'll explain, I think one of the biggest barriers to effective tribal juvenile services is all the craziness that goes on between the different agencies that are in charge of different parts of it. Also the ICWA recommendations. So the idea in the report is to expand the Indian Child Welfare Act to apply to juvenile delinquency proceedings. That's something that so I didn't think Obama would be elected, and I did not think that the VAWA amendments would pass. So I don't think that we'll change ICWA, but I hope that I'm wrong in the same way. But it should be done. It doesn't make any sense. All of the logic of ICWA applies in the juvenile justice context. And so I think that's a revolutionary recommendation in a report like this. So mostly what I have are sort of small tweaks and some questions about it. I did wish that more attention was paid to tribal systems in the report. So the focus, I think, in the juvenile chapter is really on eliminating other systems as much as possible and strengthening tribal ones, but not at looking closely at the specific issues that are faced by tribal systems when they do operate. And here, I think when you read it with the other chapters, you can see a little bit more of that, but I think it's important to be honest about the bad acts, the bad stories. So the bad things that kids do, we shouldn't hide those and pretend that they're not happening. We also shouldn't let those stories overwhelm the stats. So the stats are pretty clear. I think that most of what is going on with Indian kids is low-level alcohol-related offenses. And even when they're high-level offenses, they're usually rooted in some kind of trauma or substance abuse. And so when I hear policymakers at the Bureau of Indian Affairs talk about how they need to build facilities for rapists and murderers around Indian country, there just aren't that many. They do happen, but they're not most of the kids. And so we shouldn't let those stories overwhelm the full picture. But the other thing is we need to be honest about when kids are harmed in tribal systems. So tribal systems are not perfect, and no system is, but pretending that bad things don't happen in tribal systems is not the right way to go. I think being honest about when bad things do happen and trying to figure out what needs to be in place in order to support tribal systems being better is really important. And I sort of wish the report did more of that. So I want to emphasize the issues by jurisdiction. So I try to think of things from the perspective of, okay, you have a Native youth, where might they go? But the issues for Native youth are completely different depending on which system it is. So the worst problems in the federal system, and I agree with a lot of what the report says, are invisibility and distance. So nobody knows where the kids are, they're very far away, and they're totally invisible on a policy level. It is an accidental system. So it is a policy, so there is no federal juvenile system, but there is because there are a bunch of Indian kids there. And it was, so it was never created in the first place, so nobody's thinking about what that policy is. And where policy is set at the federal level, the kids that the policymakers are thinking about are terrible interstate drug lords. So there's this imagined horrible offender. So for example, there's a provision in federal law that makes it easier to put kids in adult court. It lowers the age. That is a provision that affects Native kids, but it was passed in a bill that sort of was built on fear of predatory interstate drug and gang offenders. So it's a system built with someone else in mind, and then it's basically Indian kids that are affected by it. And then on the federal level also, there's another issue that isn't mentioned here, which is duplicative enforcement. So we talk a lot about under-enforcement in Indian country, but sometimes what happens is a tribe wants to proceed with a delinquency petition, and then the feds do it too. And sometimes they do it in a way that totally undermines the choice the tribe made. And in a situation where we have scarce resources, there's no excuse for duplicative prosecutions that undermine each other. So that should never happen. And that's a big problem when it comes to federal jurisdiction. With state courts, so where Native kids are in state courts, sometimes this happens because of jurisdictional arrangements where the crimes are committed in Indian country. Sometimes it happens because there are, the majority of Native kids actually live off of reservations and commit their crimes off of reservations. And the biggest issues there, I think, are disproportionality. So you don't hear about, in the conversations about racial disproportionality, you don't hear about Native youth a lot. When you break it down, so nationally they're invisible because they're less than 1%, so they don't count on any of the stats. But if you look at the places like Alaska, where there's a significant number of Native youth in the system, Washington State, I've seen a few states like this. When you break it down at the county level, if there's a lot of Native youth there, the disproportionality statistics are as bad or worse as they are with any other group. So you can't see it, but that's a really big deal at the state level. So they are more likely to be referred to court, they're more likely to be taken out of the home, they're more likely to be in secure detention, and they're more likely to be prosecuted as adults almost everywhere. So that I think is the biggest issue in state systems. The other issue with states is this lack of communication with tribes. So tribes basically have nothing to do with what's going on when their kids are prosecuted in state systems, and that is a real problem. On the tribal level, the major issue is lack of funding and resources, but a specific issue underneath that is lack of funding for facilities. So there's a need for buildings, and the buildings might be for any number of different things, but there's a lot of places where in order to provide some services, a building needs to be built, and it's hard to get money in Indian country, but it's even harder to get a building. And so I was working for a tribe where they were taking jurisdiction over child welfare, exclusive jurisdiction over child welfare. So they needed to put some resources into their child welfare system. But they ended up being able to get a grant to build a building, and the building was going to be a high security juvenile detention facility. And they needed a building, but what they really needed was a runaway shelter or a child welfare shelter. But since the only thing they could get was a grant to build a building that was a detention facility, they had to take their whole system and move it into secure juvenile detention when it wasn't what they needed. So they needed a building, but they needed a building that they could do what they wanted with. And so I don't think we should we need to focus specifically, I think, on the facilities funding in addition to just funding in general. And then the other issue at the tribal level is the federal agency policy influence. So federal agencies set policies at the tribal level in a very insidious way. So the system, a tribal system, it's a bunch of different pieces actually. So there's police, and then there's courts, and then there's prosecuting attorneys or probation officers, and there's defense attorneys, and then there's incarceration or short-term detention facilities, and all of those might actually be run by a different entity. So some could be run by the tribe, but some could be run by the BIA, and the building of the facilities could be the Department of Justice. So you have a bunch of different people, and agencies could be in charge of different places, and depending on what those agencies feel like doing, they can kind of change their minds. So you heard on the last panel about facilities that were built by the Department of Justice and then stand empty and are not being run by the Bureau of Indian Affairs. The story about that is in the 90s, there was a report criticizing what was going on in Indian country juvenile facilities. There were kids that were committing suicide and kids that were in really unsafe conditions. And there was a push to build new facilities, and it was a partnership where DOJ funded the facilities construction, and BIA was going to fund the operation of maintenance, and the tribes were going to participate in running them. And the BIA, I think, got a little squeamish because of this criticism, and they wanted to be more careful about the kind of facilities that were being built. So tribes were asking for facilities. Many of them had low-level offenders that needed substance abuse treatment. And DOJ gave them grants and they built the facilities, and then BIA changed their policy and said, we're not going to do these things we call halfway houses anymore. We're only going to do regional level high security facilities that are extremely safe and extremely secure. And so we're not going to do what we said we were going to do in terms of operating your facility under that agreement unless you put in your money to retrofit it, basically, to make it high security. Most of these tribes don't need high security facilities. They have kids that basically are doing low-level alcohol offenses. And so then the facilities rot, and they're still rotting. And I fought when I was in practice in DC for years with the agencies over these facilities. And the problem is, so that's a specific story, but that policy is all agency level. So there's nothing in federal law that says that they can't run a halfway house, but the BIA didn't want to do it then, and it wasn't what the tribes wanted. And so you get these rotting facilities that are being used as warehouses. And so that's all sort of agency level policy. And we heard on an earlier panel that at the BIA, this is agency level policy that's being set by an office that's basically staffed by police. So the BIA is very good at providing some kinds of services with respect to training police and setting policies that are police oriented, but not so much, they're not detention policy experts necessarily. And so we have the whole range of juvenile justice policies being set in an agency that basically is a law enforcement agency. So there's a lot of problems with that. And I think that's actually the biggest issue at the tribal level. So I hope that consolidating and moving the agency responsibility will help that, although I think there's more to be said. So a couple of comments about the specific recommendations. In the federal area, so there's a lot of recommendations about opting out of federal jurisdiction, requiring tribal consent for any charges that where the tribe has not entirely opted out. and then amending the Juvenile Delinquency Act to add tribal declination. I actually was wondering if just the amendment to the Federal Juvenile Delinquency Act is enough. So the way it works with the states is basically juvenile justice is a state concern. And there is this federal law, and it says essentially, unless a state says that they can't do it or they don't want to do it, we will never bring kids into federal court unless it's a special kind of interstate federal type crime. And what they do with Native youth, where there's tribal jurisdiction, is you heard the statutory text, but they go to the state and they say, hey, state, do you have jurisdiction? And the state says no, because it was Indian country. And that's the certification process for getting Native youth into federal court. So not only are tribes not in the law, but they're basically dealt with through the state, which is completely backward from all the recommendations that the commission made and that already should be existing. But I think that if that was amended to add tribal certification, so you have to certify that the tribe can't or won't take it first, you would not have very many kids in federal court. So I'm not sure if there's actually a need for the opting out of federal jurisdiction and the requiring of tribal consent for charges if the Federal Juvenile Delinquency Act is amended, and that seems like a pretty easy fix. Where kids are prosecuted in federal court, there's the idea of having a pretrial diversion program to tribal courts. I wasn't clear on that because if federal courts are only seeing kids where tribes don't want jurisdiction, then I don't understand how a diversion program to tribal court would work, because these are tribes that don't want jurisdiction. So I wasn't sure how that would work, although I think it's a decent idea. Then there would be no need to invoke federal jurisdiction very often. And I think with adults you see federal jurisdiction invoked because you want a longer sentence, but you won't see that with juveniles, because juvenile jurisdiction just goes until you're 18 or 21. It's not a sentence for years proportional to the crime. So you wouldn't really need federal jurisdiction, and I think you could get the federal courts out of it a great deal just with that amendment. Federal courts could be required to contract with tribal facilities wherever they could instead of state facilities if you want the kids to stay, when they're in the federal system, to stay in the tribal communities. And something I thought of as soon as I got up here, and I'm not really sure about yet, is I wonder if tribes should be allowed to pick states instead. So if they don't want to have a kid prosecuted in the tribal system, could they opt to use states instead? And the reason I say that is because in juvenile justice in particular, the federal system is awful. It's not a system. So it's not the same as regular criminal prosecution where there actually is a federal system. And in that instance, I could see why some tribes might prefer to go with a state system that at least has juvenile services. It's laughable that you have to certify that a state has no services for juveniles, because then they go to federal court and they have no services for juveniles. So on data, so yes, there should be so much more reporting. It should include where kids are housed and under what authority they are housed. So when they are under federal authority but in a state facility, that has to be part of the reporting. And the federal government should be required to comply with disproportionate minority contact reporting requirements. So states have to report and track minority contact, and the federal government is not part of that. That's an easy amendment. Never double prosecute, I said that. So it should never, ever, ever happen that if a tribe makes a choice to proceed against a kid and the tribe makes a particular choice, that the federal prosecutor, without the tribe wanting to, should come in and prosecute after that. That just should not happen. Okay, on state systems, I got the wrap it up sign, but I'll go a little bit more. State systems need to collect DMC data on Native youth, and they need to consolidate it along with their other data and report it to the federal agencies. And on a broader level, Native youth need to be part of the conversation about disproportionate minority contact. They are not really on a national level, and they should be. And that's something that doesn't have to be all tribal policymakers that are doing this. This is something that's happening outside of Indian country. And then the development of particular interventions that take into account the cultural and historical circumstances of Native youth can be part of that. And so that can happen in state courts. It doesn't even have to be led by tribes. I want to skip down a little bit to the ICWA recommendations. So I think those are great. Basically requiring notice, intervention, and transfer for youth in Indian country, crimes that arise in Indian country. And then where crimes do not arise in Indian country and the kids are just in state court, actually ICWA-style notice and the opportunity to intervene for tribes would be, I think, incredibly important. The other way to do that kind of bringing in of tribes is on a non-individual level. So the Juvenile Justice and Delinquency Prevention Act that gives funding to states could be easily amended to require that if states get federal funding, they need to consult with tribes. So they need to bring tribes to the table. Maybe they need to give tribes a slice of the money that they get, and they need to let tribes decide what the outcomes will be for Native youth in the system. There's no requirement that states do that now, and they basically don't do that. So they get federal money, tribes don't get it, and they ignore the tribes completely. On the tribal level, so the report says if a tribe should be allowed to take exclusive jurisdiction, and then there's this language about it being conditioned on full rights, constitutional rights. So if the constitutional rights match the federal system, then the tribe can take jurisdiction. And I'm really torn about this because I love constitutional rights and I love them for juveniles. But I wonder if this might unduly push in a direction of adopting an adversarial and retributive model. And this is something that's especially inappropriate for juveniles. So it's basically, a juvenile system is a treatment-based system, or it can be. It's not even necessarily a criminal system. It could be a civil system. And so saying that the system needs to kind of mirror, in terms of its process, the federal system, which is not a juvenile system, might actually really hamper the possibility of creativity at the juvenile level. So I could think of some specific examples, but I'll not go into them right now. Funding through block grants, I think, is essential. So it all needs to come through one agency, and tribes need to be able to pick what they're doing. I will just say one word about the specific laws here. So the Tribal Youth Program is the basic grant that tribes get. It's not authorized. It's basically done on appropriations every year. It's about $10 million. It could be easily authorized as a set-aside in the Juvenile Justice and Delinquency Prevention Act. It needs to be done in a way that won't decrease the $10 million. So it can't be any less than $10 million ever, but it can be authorized through that law as a set-aside of the state block grants. And that should be done so that TYP exists every year and tribes can depend on it. And then it shouldn't be specific to a policy priority of the agency. It should be whatever the tribes want to do. Probably not just juvenile justice, but child welfare or something related as well. And I don't know how to do this, but it needs to include mental health funding. So we haven't really talked about that, but that's all in IHS and in SAMHSA. So it's not moving what's in the BIA over to the DOJ is not going to help that. So building mental health treatment and drug treatment facilities, the waiting list for facilities that are medical is way longer than the waiting list for jail facilities. And so I don't know the answer to this, but taking the money and putting it all together and letting tribes use it for what they want has to include medical treatment money too, so that they can use it for mental health and trauma treatment. And I think that's the seed of that is in the report, but it's not specific. So the last thing I'll say here is just in terms of a model. The way I think you build a good juvenile facility is you assess the needs of the community and the resources that the tribe already has and what the underlying issues are. Then you build a creative system to do it. And tribes have tons of room to do that, but they don't always take advantage of it. And then you figure out your best intervention with an eye to whatever your circumstances are. And then you go to the federal government and you take resources that you should have full freedom to use and you put them there. You build buildings, you do drug treatment, you do whatever you want to do. You don't limit it. And to ask tribal leaders to figure out how to do that when they have everything else in the world to do is crazy. And so there should be a national level group whose job it is to kind of think about best practices, not to force tribes to do it, but to help them share the practices that they're doing that are good, because some of them are great. And then to kind of suggest new ways to go. So something like the Indian Child Welfare Association, but for juvenile justice. And then there should be links made with organizations that can support what tribes want to do. So that will end with this very quick story, which is I worked for this court in Alaska, and they got this money to do this juvenile, basically prison. And the first thing that they did was send their judges, to an expo, a prison expo in Texas. The federal grant came, and the grant gave them money to fly from the top of Alaska to Texas to go to an expo where what they had was like cattle prods. You know, it was an expo of prison stuff. At the same time, so the federal money is funding putting a link between tribes and basically prison industries. And at the same time, the other day somebody called me and said, hey, I work for an organization whose job it is to partner with jurisdictions to make sure that their educational services that they provide in their juvenile facilities are good. Well, we just heard that there's no educational provided in these juvenile facilities, and she couldn't find tribes. She was like, how do I get to the tribes? So there's these great organizations out there that could actually help tribes, and there's nothing facilitating that link. And then the BIA is facilitating a link with cattle prods, and that's the end.
Thank you all. So we're going to take about another 15 minutes or so to finish up this panel, and I thought I would start by giving each of our commissioners a chance to do a brief response to the commentary, and then we'll take some questions.
I think one of the last things she said is one of the most, actually, I loved all your comments. So I'm so excited to hear from the juvenile expert, because you know what, tribal court judges don't get that luxury very often. But one of the important things that I think that this report needs to stand for is all the money that goes to tribal juvenile programs, including juvenile detention, that amount of money and probably more for parity needs to go to tribes. And part of the reason I said that is because one of the comments that was just made was that whether it's delinquency or abused and neglected or dependent children, that those services have to be available. One of the reasons that Commissioner Ellis and I sort of disagree or have a hard time, I think, with this issue, and I always call her my conscience on this issue, is because there are juveniles that are committing serious crimes and they're a danger to their community. But the question you pose is, so what do you want to do about that? If you have a 16-year-old who is a danger to your community, doesn't it make more sense to put him in a secure facility where if he needs a particular kind of treatment or has a particular kind of mental disorder, that he be in that secure facility that is specifically geared toward addressing the problems that are part of his adolescent behavior? And if we don't do that, isn't he going to do that again when he's 20 and 25 and 26 and 27? So that sort of relationship to the idea that juveniles should be treated by juveniles, and in my estimation, I think they should all be treated like dependent children. Virtually all or most of the kids in Indian country who are in the delinquency system were abused and neglected kids. So what you need to do is treat them all as if they were abused and neglected kids. But that means the feds have to give us the money for the services. And they're used to billing jails and giving us cattle prods, apparently. So to be able to train the people in the federal system to know that there needs to be secure facilities. I have this huge luxury at Tulalip because our case, we don't have delinquency court at all. So we don't prosecute any child as a delinquent. Do I have dependent children who are committing crimes in the state? I absolutely positively do. But I have the luxury to leverage services because the child was abused or a neglected child that the state doesn't even have. So changing the way we think about that, I think, is absolutely critical. And then something that Professor Fletcher said is important. You know what? States absolutely have an obligation to these kids. They get money from the federal government for Native kids and to provide services for Native kids in particular, and they do not pass any of those funds through to tribes. They're not even at the table. They don't even ask them the question. So to have the state start keeping statistics of how many kids they have and what services they provide is absolutely critical from a funding perspective. So I am very sympathetic to the fact that we need to have safe communities, but I don't think detention is the answer to that. Secure facilities that treat kids for whatever causes them to behave in that particular way, I think is superior to that problem. Otherwise, they're on my adult criminal calendar.
I'll take a point of personal privilege and just exclaim over how proud I am that people like Addie Rolnick and Sam Ennis are here today, and they are my former students. So, yay. Yay. There are actually only 2 points I want to make some observations about. One has to do with a concern that Addie appropriately raised about the constitutional rights language in our recommendation, and about the worry that that will destroy some of the space for creativity. This is not just something that we were thinking about in relation to juvenile justice. This is something we were thinking about in relation to the grand bargain for adult justice as well. And this required a lot of pondering, and what really made the difference for me was the experience over the last few decades of tribes within the framework of the current Indian Civil Rights Act deploying creative programs, both at the juvenile and at the adult level, even within the framework of expectations of constitutional rights. And the way they've done it is through diversion and through waivers. That's what happens for criminal defendants in the Navajo Nation who wind up being diverted to the peacemaking process. The hammer in those cases is a tribal hammer. You wind up back in the criminal process if the peacemaking doesn't work out successfully. But the constitutional rights concerns should be capable of resolution so long as the tribal court judges are careful about securing waivers. And I think within that framework, creativity ought to be possible. The second point I want to make is that when we were at one of our site visits on the Rosebud Sioux Reservation, and they have a very new and rather well-appointed juvenile detention facility there, I asked the wonderful administrator of that facility about why there are ever cases that go from the tribal system into federal juvenile justice. Why does that ever happen? And I posed it somewhat dichotomously. I said, is it because you lack sentencing authority at the tribal level, or is it because you lack the resources to provide the kinds of programs and treatment that you think the youth require? And this was, tended to be for youth who had done the more serious crimes. And the answer was immediate and emphatic. It was not because of a limit on their sentencing power. It was because they did not feel that they had the resources, even that the inadequate federal juvenile justice system had, to provide what that youth needed. Well, that said to us that our chapters on strengthening tribal justice systems were the most appropriate response to providing for greater tribal control over their youth. Once they had the capacity to provide the services that the youth needed, they were ready to take these matters away from the federal system and from state systems, I'm sure, in the PL 280 jurisdictions. And that was a guiding light for us.
I'm just looking at my watch, and I think my time will be better served by answering questions and opening it up for other comments in the audience. Thanks.
Great. Do we have any questions? Maybe I wanted to just take the moderator's prerogative to make one comment and one plug for one of my colleagues, because the juvenile justice question, really a lot of it relates to me to thinking about juveniles and young people staying in school and what the graduation rates are. And we hear a lot about the bad or the low graduation rates of many minorities especially within the state of California, but very little about graduation rates from high schools of Native youth in California, and those are actually the lowest, as I understand, of any group. And my colleague, Professor Dwayne Champagne, who is here, is doing some research on that now, and also researching the viability of tribal schools and whether these will begin to sort of change the course of graduation, which is also, I think, another piece of this puzzle of what happens to juveniles in Indian country is the promise of education. So just to put that out there as a comment that I thought might add to the discussion. So any questions for the panel? Yes, ma'am.
I wanted to say, I think that there's a tendency for us to see our own yard, a tendency for that. I appreciate the fact that the commission has made many site visits in various places, but I think the commentator was kind of close to the topic and didn't, I couldn't imagine the BIA giving my tribe a worn out building to use because there just aren't any around there to be used. That's just an aside. I think one of the things that we've run into over the past 10 years with Wolfchild v. U.S. is the federal government constantly trying to say, oh, it's not a tribe, it is a tribe. It's a community. No, it's a village. And when you start to use language like tribe, it sounds so innocuous, but I really believe that you need to define tribe in a really broad way that will include all the communities, tribes, and villages that have governments. And one other thing, we keep talking about the money. We got to get this money, and I agree. Block grants are invaluable and should be always something to reach for. But if you're going to go for federal dollars, of course, you know they print them on demand, but where they send them is, you know, probably to the stock market and then back. It's like a laundering scheme, it seems to me. But the idea that I have is that, for one thing, you're going to have to come up with a budget, and I think there's a bill involved here where there's going to have to be a commission that writes this bill and makes it not only valuable but relevant to all the communities and tribes and villages, so that you can come up with a budget that each one of these places needs and can use to develop the kind of law and order that we're talking about here today. And believe me, I'm on board, I'm down, I'm with it. But you can't involve healthcare while you're at it. That's another thing, because you got to stay focused on this and get that money on a budget and present that as an appropriations bill. And so the work has only just begun, but it's a beautiful piece, and I commend you.
Thank you. Can we take one more question and then give a chance for response to any of the comments or questions made? Yes.
I just want to say this is just amazing and how much I appreciate hearing it. And I really want to commend Judge Pouley, because I think at the end of the day, I work in education and I'm always telling my students, caution, human beings are here. And that we forget, or we don't forget in this room, but I think we have a system right now that for the most part is absolutely opposed to adolescents that are not conforming a certain way. And I totally agree, the research in adolescent development is, if you're imprisoning students, and Pedro Noguera has written a lot about the school to prison pipeline, that we're just setting them up, and that the resources that need to take place are those resources that help them develop as young people and within their communities. And I've been to Rosebud, and I know they do need those resources, and had they had them, they can make the changes. And I do somewhat respectfully disagree with the comment that mental health and law is different. In my mind, of course, in education we get to merge everything, but in my mind, we have to have those together, because we're looking at programs that can heal students and also ideally provide a supportive system for growth. And so I think that somehow needs to be in your dependent model, that these are dependents, and how can we support their growth as young people? And when they get in trouble, rather than throwing them into a system that will guarantee that they will become criminals, we give them second, third, fourth chances. So I just want to commend you all for what you're doing. But that idea that, you know, this is the next generation, and how do we change not just what's happening there, but also in our cities, where the mindset against adolescents is quite negative.
Would our commissioners like to respond to any of those issues
Can I
raised?
real briefly? I just want to say, I think one of the biggest challenges that we had in writing this report was finding where we would draw some sideboards. There's no doubt that alcohol and substance abuse is very closely linked to a lot of crime, particularly with Native youth. So just as a point of clarification, we didn't feel like it was a little outside of our scope of what we could discuss, but certainly this is just a beginning of talking about things that need to happen, and investing in those kind of preventive programs to address those problems is key. So.
I wanted to comment a little bit on both of yours, but in particular on what you said about education and graduation rates for Native students. So at Tulalip, when you turn 18, the Tulalip tribal members get per capitas, but they go in trust if you're a minor. And when you turn 18, you get those per capitas if you have your GED or high school diploma. And if you don't, then you have to wait until you're 21 years old to have it. So the enrollment department just did statistics that said 50% of the Tulalip kids did not graduate or get their GEDs, but took that money at 21. 50%. 50% of Tulalip kids didn't graduate from high school. I don't think that it is, in a lot of respects, sort of what Commissioner Goldberg started with. I fought to have this be chapter number 1. And at the end of the day, what she said is absolutely right. It sort of summarizes all of the issues that are in the recommendations, and no more true than intergenerational trauma. If we do not resolve the issue of the trauma that Native kids have experienced in schools, and their parents experienced, and their great-grandparents experienced, we won't ever be able to get to a spot where we can teach education as a positive value. So recognizing that you have to be able to treat the trauma to be able to put people on an even playing field is absolutely critical. And Tulalip does great at a lot of things. So I love being a judge there. I love bragging about Tulalip. It's just a wonderful place. But I have to tell you, those kids should be graduating. It breaks my heart that 50% of them aren't. If that was any other group, if any of you in this room had that happen in your community, the full panoply of federal and state resources would be thrown at your community to fix it, but not in Indian country. So I'm really happy that Professor Champagne is working on that project. I'm glad you brought that to our attention. And it just absolutely positively summarizes how we have to care for our children. They are dependents until they're adults, even when they do bad things. And there's proper resources that can be leveraged to do that.
Okay. Any more responses?
Can I just say one thing?
Yes, of course.
So regarding Judge Pouley's comment earlier about alternatives to detention, and in the report sort of makes a recommendation that I think you were calling it sort of I don't think you said revolutionary, but it's a big deal to come out and recommend that you not use detention. And it is a big deal, and it's also not a big deal because it's not that controversial anymore in juvenile justice to say that alternatives to detention are better. And this is what's surprising to me, is that what I see, so I think tribes should be able to decide what they want. I support alternatives to detention. I don't like detention, but I guess if a tribe wants to do it, they should have the freedom to do it. But what I see over and over again is tribes, what they want is something that looks like a detention alternative structure, and what is actually the best practices recommendation by juvenile justice professionals is that. And then somewhere in the middle, there's this disjuncture where in Indian country, it's pushing toward detention, where everybody else is sort of saying, that was actually a really bad idea. So it's replicating the worst models of Western systems when it doesn't actually have to. And that's what sort of is the most distressing. So the Casey, you mentioned the Casey Foundation has this detention alternatives project. So they basically go out and they find a jurisdiction that wants to decrease their reliance on detention and help them do that. And they have trouble, again, they can't find enough tribes. They want the tribes to come to them and do that too. And the tribes actually want, when you talk to them, less reliance on detention, but there's sort of a missing partnership there. And so I think that what you're recommending is actually completely, this is why it's easy in a way. It's not controversial in terms of what the rest of the juvenile justice community is saying, and so it should be embraced by them.
Okay, we'll take one final question. Yes.
I just wanted to say that I think we need to also acknowledge how far we've come. Because in 1968, when the NAACP did their examination of Indian country, fully 2/3 of American Indians on reservations were functionally illiterate. So I think we've come a long way, and we need to applaud at least that. Certainly there's further to go.
We're wrapping up a little early because of Friday afternoon traffic and so many people who have to get to the airport. So please join me in thanking this panel.